So what does the court decide? Well, it's a decision by a judge named Flaherty. I don't know if that's how to pronounce it. And the decision is to deny the request. This court case is not a U.S. Supreme Court case. This is a court case that took place in the state of Pennsylvania. And it is a sort of famous, much discussed case called McFall v. Shimp. One thing to keep in mind as we talk about this case, which is from 1978, is why we're talking about it. That is, why are we reading this at this point in the course? What about the more philosophical works that we've just read does this case potentially illustrate or illuminate or something like that? Okay, but put that aside for now. We'll come back to that in a bit. Let's just talk about the facts of the case. So this takes place in Pennsylvania in the 70s. McFall has a rare bone marrow disease, is in desperate need of a bone marrow transplant. If he gets the transplant, then he has maybe a 50 or 60% chance of living, many years longer. But if he doesn't get this transplant, then his chances are almost zero. Doesn't have many close family members. And there's this guy, Shimp, whose name we are not told. His whole name, it turns out, is David Shimp. But we don't even get in the opinion his whole name because, they're protecting his identity. Shimp is a compatible potential donor. But Shimp doesn't want to donate bone marrow to save or potentially save McFall's life. Shimp is withholding his bone marrow, doesn't want to undergo the procedure, which is not trivial, right? It's a surgery for Shimp, but it is an inconvenience, whereas death for McFall is more than an inconvenience. Shimp doesn't want to undergo this procedure, and as a result, it very much seems McFall is going to die. What we have here is we have a bill in equity for a preliminary injunction. You may have noticed this is what it says at the beginning of the court case, and I'm going to explain what this means. So a bill in equity is just a request or a plea that is made in civil court, right? In a civil case. Right, so this is a request being made by McFall or McFall's lawyers. And what are they requesting? They're requesting a preliminary injunction. That is, they're requesting an order. They want a judge to give an order preliminarily. That means before they've had a chance to go through the whole case. Here's a typical case of a preliminary injunction. If, for example, I'm about to publish a book, and you think, or you're claiming that you really wrote that book, or you wrote parts of the book, and you don't want it to be published. You really own those words. We need to have a court case, a civil case, to decide, whether I get to publish the book or not. And there's a publication date, and it's set for 2 days from now. A judge might issue a preliminary injunction to say, wait, we haven't had time to go through this whole case yet, but preliminarily, at the beginning, I'm just going to pause the publication of this book. You can't publish the book yet, but we're going to take our time and we're going to hear the arguments of both sides and we're going to decide who owns the rights to this potential book, right? And so you pause everything so that there's enough time for the case to be heard. Well, this is a somewhat unusual instance where the request being made or the plea being made by McFall is not to pause something, but it's a request for an injunction requiring Shimp to undergo a series of tests and then ultimately to donate his bone marrow. So the question before the court is whether or not the court should force this person to undergo a surgery that he does not want to undergo for the benefit of another person. It turns out, by the way, although this wasn't in the opinion that we read for today, that they're cousins. That's why there's a match. Shimp is McFall's cousin. Anyway, so what does the court decide? Well, it's a decision by a judge named Flaherty. I don't know if that's how to pronounce it. And the decision is to deny the request, deny the plea. That is, the court refuses to force Shimp to undergo the bone marrow transplant procedure. Okay, that's the decision. Here is something that Flaherty says in the opinion, the short opinion that we read for today. Here's what he says. Morally, this decision rests with defendant. And in the view of the court, the refusal of defendant is morally indefensible. Shimp is the defendant, McFall is the plaintiff. What Flaherty is saying here is that Shimp's refusal to donate bone marrow is wrong, is evil. I want to point out that there's an important distinction to be drawn here between like the moral decision of, Shimp, he's the one who would have to donate the bone marrow, and the moral decision potentially of the court. You might think, it's very natural to think, that there's a conflict between morality on one hand and legality on the other. Like, here's a classic case of this sort of thing. You're a judge before the Civil War in Massachusetts or something like that, or some northern state, and there's an escaped slave. And the Fugitive Slave Act, which is a federal law, which is binding and applicable, right? The law says that you have to send this person back into the grips of slavery. That's what the law requires. But you might also think that, well, morality requires you not to do that, not to send this human being back back to their slave master, who will undoubtedly punish them harshly, but also just keep them in slavery for the rest of their life, right? So you might think there's a conflict that the judge has to deal with between what the law requires and what the moral law requires. That's not what's going on in this case, and that's not what the judge in this case says is going on. What the judge is saying here, when he says morally this decision rests with the defendant, that is, there's a moral quandary or a moral problem before the defendant, Shimp, right? Shimp has to make a moral decision, and the judge just says his opinion about what moral decision Shimp should make, right? In the view of the court, that's the judge, the refusal of the defendant is morally indefensible. That is, he's doing the wrong thing by withholding his bone marrow. But what we have here is not really a straightforward conflict between morality and legality. Because, well, take the two possible people who are making decisions. There's Shimp, who's making a decision about whether to attempt to withhold his bone marrow or not. Well, the law, according to the judge, doesn't require Shimp to do anything one way or another. So it's not like the law requires him to do something and morality requires him to do something else. No, the law just simply doesn't tell him what to do one way or the other, and morality, according to the judge, tells him to donate, right? So you have, for Shimp at least, right, you have donate your bone marrow versus, well, nothing, no recommendation whatsoever by the law. Then, well, what decision is before the court? The law requires the court not to grant the bill in equity, that is, not to issue the injunction. But if you actually read the court's opinion, if you actually read the judge's opinion, you realize that the judge is making a whole bunch of moral arguments. That is, according to the judge, morality also requires no injunction. Morality demands, the judge thinks, that he rule in favor of Shimp and deny the preliminary injunction. And as a result, by the way, that's what the judge did. 2 weeks later, I believe it was 2 weeks after this decision was issued, McFall died because of his bone marrow disease. So the results came rather quickly. No injunction. But the argument that was given was a moral one. Here's something that Flaherty says. He says that bodily security and individual rights are, quote, the very essence of our free society, and that the court and our society must preserve, quote, the sanctity of the individual. This is moral language. This is a moral argument. So even though the judge thinks that the law clearly says that he should issue no injunction requiring Shimp to donate his bone marrow, so too he thinks that there's a moral argument underpinning the law here, and that moral position, the moral position of our society, he says, of American society in the 1970s or Pennsylvanian society in the 1970s or whatever, he thinks that the moral foundation of that society is the right moral foundation. He even mentions that there are other societies or other places in the world where individual rights are less valued, where the needs of the community are thought to be more important, and he just thinks that they're wrong. They're wrong about the moral facts. This judge is making a moral claim in this opinion, and the thought is there is no conflict between morality and legality. Well, on Shimp's part, Shimp merely has a moral requirement and no legal requirement at all, and the court has the same moral requirement as it has a legal requirement. So there really is no conflict here to be found, at least not of the traditional kind where morality tells you to do one thing and the law tells you to do something different. So in addition to distinguishing between the different decisions that are going to be made, the decision of Shimp and the decision of the judge, right? I also just want to, more clearly distinguish moral and legal duties and rights. You might think that Shimp has a moral duty. And you might wonder, well, how can he have a moral duty if McFall doesn't have a right to receive this potentially life-saving bone marrow donation, right? And it would seem like for every duty, you need a corresponding right. And McFall, the court is arguing, doesn't have any right like that. And so how could it be that Shimp has a duty? Well, the answer is this. Shimp has a moral duty, and McFall does have a right. It's just a moral right. McFall, it seems to me, has the moral right to receive this bone marrow donation. That is, he has a legitimate claim on Shimp, a moral claim, not a legal one, right? A moral claim that Shimp must give him the bone marrow because the cost to Shimp of the bone marrow donation is very minimal, right? And so for this duty that Shimp has, McFall does have a corresponding right. But, well, Shimp has no legal duty, one way or another, and so correspondingly, McFall has no legal right. The moral facts about what Shimp should do and what McFall has a right to, the moral facts differ from the legal facts, right? But it doesn't mean, well, therefore, that there's a conflict, because in the legal case, there's just a mere lack of a duty, as opposed to a duty to do the other thing, right? As opposed to it would be different, it would be weird and bizarre, and then there would really be a conflict for Shimp if morality required him to donate his bone marrow and legality required him not to. But there's no requirement not to donate his bone marrow. It's just a lack of a requirement to donate it. There's one last thing I want to discuss very quickly, which is why we're talking about this case. This case is helpful for illustrating some things about legal positivism that we were discussing last time, right? Legal positivism, you'll remember, is the view that law is a social phenomenon, that law is, well, posited into existence by human beings, right? And legal positivism is a big umbrella term that captures a whole bunch of different theories of law, including Austin's theory that we've already been talking about, including H.L.A. Hart's theory that we're going to talk about very soon, right? And so it's a big, broad umbrella theory. It includes the claim that law is a social phenomenon, and it also includes the separation of law and morality. Unlike natural law theory, you may remember, legal positivism says that there's no necessary connection between law and morality. There's no necessary moral constraint on legal content. But you may have noticed that there's all sorts of moral arguments that get made in this opinion, in this court opinion issued by a judge, supposedly stating what the law is. We get seemingly a lot of points about what the law ought to be. Why aren't we just reading in this court case? If social positivism is right, why aren't we just reading a whole bunch of accounts of social facts? Why doesn't the judge just simply say, well, here's the law as it was passed by a group of people on this date? That's a social fact. This group of people, they said these words in this chamber, they banged this gavel. Those are all social facts about what people thought and said and did. Why isn't the opinion just a whole bunch of social facts if law is fundamentally a social phenomenon? And why do we get a whole bunch of discussion of moral claims if there's supposedly this separation between law and morality? Here's the question. Does the fact that this judge appeals to morality over and over again in determining what the law is, does that fact show that legal positivism is false? The answer is no. And that's because legal positivism is not really the claim that law is merely a social phenomenon, but rather it's the claim that law is something like ultimately a social phenomenon. So here's what I mean by ultimately. It could be that moral facts are relevant to determining what the law is, according to legal positivism, so long as those moral facts are themselves only relevant because of some more fundamental set of social facts. So for example, here's some social facts. A whole bunch of founding fathers and mothers or whatever, they get together in the council or whatever, and they write the Constitution. That's a social fact. They write these words down, on a piece of paper, and they all nod their heads and they say yay at the appropriate times. Those are all social facts. But what if one of the social facts, that is one of the sentences that appears in the Constitution, says something like, well, if you want to know what the law is in this particular kind of case, go check morality. Go check what is just. These laws are meant to capture justice. If there's anything like that in the Constitution, then there are social facts, and they, as it were, point towards moral facts. In that way, legal positivism could be correct. It could be true that ultimately law is determined by social matters. It's just that along the way, moral matters come into it because the social facts, as it were, refer to or allow in or open the door for the moral facts. This judge, the idea is only able to appeal to morality because there's some social facts that say that the law is partly determined by morality. That was the point of that example of writing the Constitution, where the Constitution refers to and makes use of moral terms and moral concepts. That's the important clarification, right? And similarly, just like legal positivism is not the theory that law is a purely social phenomenon, but rather it's the theory that law is an ultimately social phenomenon, so too, legal positivism doesn't entail that there is no connection between law and morality. It's just that there is no necessary connection. It doesn't have to be the case that some law meets some minimum moral standard in order to be law, though it can sometimes be the case that there is a moral test for legality. Okay, that's it.